yesterday, the Supreme Court of India had a hearing about Sudarshan news channel. Yes, this is the channel that claimed to expose the infiltration of Muslims in the civil services of the country. The program had also come into a judicial scrutiny before this, before the Supreme Court of India and the Delhi High Court earlier when the promo of this program was released. But back then, the Supreme Court had refused to put any pre-broadcast ban on the program. But after airing of 4 successive episodes of this program, the Supreme Court was again called out in regard of the case. 7 former civil servants filed an application in the Supreme Court against this controversial program. The hearing of this happened yesterday in the Supreme Court of India, and here are 5 major key takeaways given by the Supreme Court on this case of Sudarshan News on airing of the show of the UPSC Jihad expose. First, while talking about some guidelines for self-regulation of the media, the bench of the judges made it very clear that they need to look into the model of ownership of visual media. The revenue model of the company should be put under a clear check to see the involvement of ads, they said. That whether the ads are being distributed equally or some sort of an unequal distribution of ads is taking place in some programs. Second, the bench made it very clear that the freedom of media is on behalf of the citizens of the country, that is India. They said that the journalistic freedom in the country is not at all absolute. There isn't any separate freedom for the journalists like certain countries like the US has, and thus the operation of journalists need to work around the right to fair comment. The Supreme Court judge bench made it very clear. Even being a part of democracy cannot stop us from having certain regulations, certain special standards in place. Also, the Solicitor General said that electronic and print media cannot be compartmentalized on several bases, and thus the law does not have to regulate everything in order to regulate certain things that are very specific. Third, while talking about more regulations of the visual media, to be more specific, television, the bench said that the reach of television is more penetrated into the audience of India, and that is because of the entertainment factor that the media offers, and thus quoting the Rule 6 of the program codes, which said programs cannot show something that is that targets a particular community of the country, and thus the bench questioned the extent to which the courts can control the publication of content on several media forms. The talk of TRP, sensationalism of content of electronic media, was also addressed very specifically by the bench of judges. Fourth, addressing section 19th and 20th of the Cable TV Network Act that puts a bar on promoting something that has a communal disharmony or targets a very particular community, Advocate Farasat brought in certain segments of the show, like the shot of an ISIS face, which according to him, he said, promoted hate speech and communalism very clearly. To this, Justice Chandrachud said that saying something like the Muslims of the country are infiltrating civil services cannot be allowed by the Supreme Court of India. Fifth, the bench of judges was of the opinion to appoint a 5-membered committee that would be specifically looking into certain standards for the electronic media operation. The bench strongly contrasted with the Press Council of India also, and said that if a body would have actually been in place, then things would have been completely different from what they are today, and we would have not seen what we are actually seeing on television on an everyday basis. With all this being said, the bench of judges of the Supreme Court directed Sudarshan TV to defer the UPSC Jihad expose broadcast until any further hearing from the Supreme Court of India.